The Manhattan District Attorney's Office filed their response to the defense omnibus motion in the Luigi Mangione case, and it's 80 pages long, so let's get right into it. Before we go step by step, I'll just say my general takeaways. I still think, now that we've seen kind of a little bit more of the arguments on both sides, that this is a murder 2 case, not a murder in the first degree case. I do not think that they're going to be able to make out the terrorism element that they need to bump this case up from a murder 2 to a murder 1. Do I think it's impossible? No, but now that I'm seeing kind of their theory spelled out in this response motion, I just think that it's a stretch. The other takeaways that I have are, although murder 1 is a stretch simply because I don't think that the elements necessarily are going to be met, murder 2, it does look like they have enough evidence to convict him. And I think at this point, Karen Agnifalo's best bet is jury nullification, which she can't argue. I mean, she's going to have to choose a defense to argue. And it looks like the Manhattan DA's office is asking and pushing to know whether that defense is going to be an insanity defense or not. But it doesn't look so good for Luigi, in my opinion. Also, of course, my takeaway from the tone of the response is that Joel Seidman definitely is taking this case very personally. Right out the gate, we have 3 sections that are pretty short responses to the omnibus motion. Number 1 is consent for a Huntley hearing. Number 2 is consent for a MAP hearing. And number 3 discusses why it's premature for a judge to determine whether the prosecution should be allowed to call non-eyewitness individuals for identification purposes of Luigi. So number 1, the Huntley hearing, that has to do with statements that law enforcement take from a defendant, whether those statements were taken properly or not. And essentially the prosecution is saying, look, you obviously can't decide that on the papers. There needs to be a hearing. We will consent to a Huntley hearing. Second was the MAP hearing. That has to do with any property that was recovered from or near Luigi. And that's going to be also argued at a pretrial hearing, and too early for a judge to kind of make that decision on the papers. And then number 3, again, this idea of other people who didn't witness the crime coming in and describing Luigi or identifying him from stills. The prosecutors are saying that it's too early for those arguments to be made because it would potentially have to do with whether Luigi changes his appearance at or before trial. And so they would need somebody to be able to identify him, comparing him at trial to the stills or surveillance footage that might look different. So it's too early to make that decision because we're not at trial yet and he hasn't changed his appearance. Then we start getting into the meat and potatoes of the motion with the factual background. Factual, as the prosecution sees it. And I'll just highlight a couple of things that I noticed, stuff that we might not have known before, which, first of all, they detail the fact that after this event happened, the police pulled like tons of surveillance video, and they end up finding out that Luigi actually had walked past Brian Thompson the night before the shooting happened while he was on his cell phone. Now, I don't know if they're going to try to claim that that's an element of some sort of stalking, but remember, the stalking charges are the federal case, not the state, so the state motion doesn't really get too much into that. I do wonder if the feds will hop on that, though, and consider that stalking. But once again, like I said, did Brian Thompson know that Luigi was stalking him at that time? Doesn't look like it. In the factual background recitation, they also talk about a bunch of different items that were either discarded and recovered, etc. And obviously they're setting that up for their later argument to show that those items were tested and either prints or DNA or both of Luigi's were found on those items. Now, keep in mind, legally, if he abandons those items, meaning he discarded them, he threw them in the garbage, whatever, he actually does not have standing to contest their recovery and testing. So, unfortunately, that's coming in. Other things that we did not necessarily know fully about that are in this motion, including in the factual background, are the writings of this so-called manifesto, and it's pretty bad. In order to establish intent and motive, which they do need to do for some of the elements of the charges, including the murder in the first degree charge, it's oftentimes hard to prove beyond a reasonable doubt, at least, what a defendant was thinking at the time of an event. You can try to piece things together based on somebody's actions before, during, and after, but ultimately you're usually telling a jury, like, here's what I think they're thinking because of X, Y, and Z. So rarely is it actually spelled out. And so Luigi's going to be facing an uphill battle now because he does write extensively in these notebooks and writings, not only what he plans on doing, but essentially how extensively he planned it, how long it took for him to plan these things out, which again goes back to, I'm remembering now, the federal prosecutors talking about why they're seeking the death penalty. And one of their kind of exacerbating elements was that it did take him, that he essentially expended a lot of time and energy to plan this out strategically. And, that leads to them saying that, like, this wasn't just on a whim. This wasn't an emotional outburst. This was somebody who meticulously planned and thought about things before executing them. So basically, we now know kind of what his mens rea was, what his intentions were, and they're going to use that against him pretty extensively. And of course, they're going to continue to call it a confession. You do see Joel Seidman, the prosecutor, kind of getting super personal about some of this stuff, like trying to insult Luigi, saying like, "Ooh, this Ivy League guy didn't understand when he complains about how many deaths there are in our country. He doesn't understand that gun violence is like a leading cause of death, and here he is shooting somebody." That has no place in this kind of motion. Those, cynical, rude attacks on the defendant and his character. There's really no place for that in this kind of motion, which is really just supposed to be a motion about the law. And so speaking of the law, they try to oppose Karen's motion to dismiss the indictment for murder in the first degree because of the terrorism charge. And I agree with her position that the terrorism charge is tenuous. Here you have Joel Seidman kind of addressing the identity of Luigi right out the gate as kind of like a no-brainer. To be fair, it probably is going to be a no-brainer in the end, right? I mean, you have the surveillance of him, you have the DNA, you have the fingerprints, and you have a confession. I mean, it really doesn't get stronger than that. So aside from proving that the person committed the act, you have to prove that what the person did fills the elements of that act, right? Again, like murder in the second degree is pretty easy to prove because all you have to do is prove A, that Luigi is the one who did it, and B, that the thing he did was shoot somebody on purpose and kill them because he intended to kill them. That's it. Murder in the first degree, in this particular case, you need that terrorism charge. And so the bulk of the motion now tries to justify why terrorism is in fact met. And so he explains that terrorism under the law could fall under one of three categories, and that he's claiming that Luigi meets all three. Number one, to intimidate a certain civilian population. And then number 2 and 3 are basically intimidate a unit of government and coerce them to kind of change their policy, or to influence policy in a unit of government by murder or assassination. So the DA is going to try to focus on Luigi's intent in order to prove those things. But the thing is, I think it's tenuous because what civilian population? He goes on and on and on and on and on about how like executives from United Healthcare and or investors are a civilian population that could be intimidated. And I just don't see it. I think that he tries to show that it could be any sort of civilian population. It doesn't have to be a protected class of people, that it could be any sort of civilian group, but I really don't think that's what the law intends. And I don't think the case law that he cited really supports that. I tried to keep this within 10 minutes, but I failed. So stay tuned for part 2.